Hello, I'm Amel Elfala. I'm a summary sheriff based at Glasgow Sheriff Court. However, today I'm speaking to you as a member of the Scottish Sentencing Council. This is the first of two lectures and will cover the role and the work of the Council. It will take just under 20 minutes. The second lecture covers the sentencing guidelines prepared by the Council for the courts. Transcripts of both are provided online with links to further material, including all the legislation referred to. At first glance, sentencing may seem straightforward. The higher the culpability or level of blame of the offender and the greater the harm caused to a victim, the more serious the offence will be and the more serious the sentence should be. However, there are many challenges for the courts in weighing culpability and harm and in determining the level of seriousness before deciding a sentence. For example, let's say we have a case where a driver with previous convictions for motoring offences speeds along a narrow, twisty road, driving dangerously for a sustained period, but who's stopped by police before causing harm. Contrast that with the case of an inexperienced driver with a previously good record causes a fatal crash due to a momentary distraction. One is high culpability with only the potential for harm. The other is low culpability, but ends up causing the most serious harm, in this case, a death. How should the judge sentence each of them? What factors should the judge take into account? Questions like these are at the heart of the sentencing guidelines which the Council produces. I should say, producing guidelines on sentencing is only part of the Council's work. But before I go on to talk about our work in more detail, it may be helpful to talk a bit about our history. In 2003, the Scottish Executive set up the Sentencing Commission for Scotland, a judge-led group to look at consistency in sentencing. The Commission carried out wide-ranging research, including studies of other sentencing bodies from all over the world. The research showed that while there was a public perception in Scotland of widespread inconsistency in sentencing, this wasn't backed up by the data. So it was recommended that a sentencing body be created to produce guidelines for use by the courts, and importantly, that these guidelines may be made available to the public to help people better understand how judges decide sentences. As a result, the Council was established in 2015 as an independent advisory body under the Criminal Justice and Licensing Scotland Act 2015. The legislation states that the Council has a duty to promote consistency in sentencing practice, assist the development of policy in relation to sentencing, and promote greater awareness and understanding of sentence policy and practice. This includes a responsibility to publish guideline judgments issued by the courts. We can also conduct research and provide general advice or guidance. One thing we don't do, though, is deal with individual sentences. They are always dealt with by the judge presiding in court. I'm going to tell you a little bit more about the Council and our work over the course of this lecture, and you can also see our website for more information on the Council and the secondary legislation that enables us to carry out our work. First things first, though, who is the Council? Well, the Council has 12 members. These are made up of 6 judges from across the court levels, a prosecutor, an advocate, a solicitor, a police officer, someone with knowledge of victims' issues, and one other person who's not qualified as a judge or legal member. I'm one of the judicial members. The chair of the Council is always the Lord Justice Clerk, Scotland's second most senior judge. All of our members are volunteers and do not receive a wage. Our work is also supported by a small secretariat team. Accountability is a crucial principle for the Council. In terms of the legislation, we have to prepare a business plan for the Scottish Ministers every 3 years. For this, we consult the Scottish Ministers, the Lord Advocate, who's head of the Prosecution Service, and the Lord Justice General, who's head of the High Court. But we take other views into account as well. For example, we also speak to the Law Society of Scotland, which is the representative body for solicitors in Scotland, the Faculty of Advocates, and victims groups. Each year, we also provide an annual report on our work for the ministers. These two reports are both laid before the Scottish Parliament. Our current business plan for 2021 to 2024 outlines how we plan to spend our budget in the future, and our annual report sets out how we've spent it so far. It also sets out our current programme, if you're interested in knowing what work we're doing at the moment. One of the key areas of that work is on sentencing guidelines. As I said, a part of our statutory duty to promote consistency in sentencing, one of the Council's primary tasks is to produce sentencing guidelines for the courts. To make sure that the guidelines are fit for purpose, it's very important to us that our work in developing them is always evidence-based. So, before we produce a guideline, we carry out a wide range of research, including looking at guidelines in other jurisdictions such as England and Wales. We interview judges to determine current sentencing practice in Scotland, and we look for any sentencing areas that they find challenging where a guideline might be helpful. We gather data from the Scottish Government and criminal justice organisations such as the Court Service, the Prosecution Service, the Prison Service, and Police Scotland. We gather evidence from people with a particular expertise or interest in the topic, and we bring people together to discuss different views. We also look at public perceptions of sentencing. We use all of this evidence to develop draft guidelines, which are then robustly tested with the help of various interested people, including judges. We also consult the public on all of our draft guidelines. Any consultations which are presently open are available on our website if you want to take part in the process. We're generally working on a number of guidelines at the same time, and what we're currently working on is laid out in our annual report. Before I tell you a bit about the guidelines we've already produced, it may be helpful to give you an idea of what sentences are available to judges in Scotland. Different types of court have different maximum sentencing powers, but imprisonment is the most serious sentence available to any judge in any court. Different types of offence will attract different sentences, but a life sentence must be given for murder. If a life sentence is imposed, the judge must decide the length of time the offender will stay in prison, what's known as the punishment part, before the parole board can consider releasing them from custody to serve the rest of their life sentence in the community. Most offences don't result in a prison sentence being imposed, though. Judges can also impose community-based sentences, such as a community payback order. There are 9 different requirements that can be imposed as part of a community payback order, including up to 300 hours of unpaid work, meetings with a social worker to address and change offending behaviour, and attending a programme to address problems relating to alcohol or drugs. A community payback order can be a very challenging sentence and usually includes a combination of some of the 9 possible requirements. A judge can also order the payment of a fine or compensation to a victim. Or they can set a curfew for an offender to remain at a certain address, usually their home address, at certain times on certain conditions. This can be monitored electronically by way of what's known as a tag. In certain road traffic offences, a judge can disqualify a motorist from driving, or they can impose penalty points on a licence. The least serious disposal is an absolute discharge or an admonition, where no punishment is given. There's plenty more information about these sentences and other sentences available on our website. Meantime, though, let's go back to discussing the process of developing the sentencing guideline. We decided to start with a set of general guidelines that would apply to all Scottish offences. Our aim is to make them concise enough to be useful as a quick reference for busy court judges, but also user-friendly for the public, avoiding jargon and technical terms as much as possible. We've published 3 general guidelines. Firstly, on the principles and purposes of sentencing. Secondly, on the steps judges should go through when deciding a sentence. And thirdly, on sentencing young people. Our first guideline on the principles and purposes of sentencing came into force in 2018 and is available on our website. It sets out the core principle of sentencing, that sentences must be fair and proportionate. Our second guideline covers the steps that judges should follow when deciding a sentence. First, a judge must consider the seriousness of the offence, which is determined by the harm caused or which could have been caused, and the culpability of the offender. This sets the level of seriousness of the offence and the sentence range for that level. Once the level is decided, any aggravating or mitigating factors must be taken into account. Aggravating factors make an offence more serious, while mitigating factors make it less serious. These two general guidelines apply to all offences in Scotland and should be read alongside each other and any guideline that relates to a specific offence. This makes our offence guidelines more concise and easier for judges to use, especially when they're sitting in high volume courts dealing with a lot of sentences in one day, with each case often involving lots of different relevant factors at the same time. Our third general guideline is on sentencing young people and deals with offenders aged under 25 at the time of their conviction. The guideline is based on research which shows that young people are generally less mature than older people and may have a greater potential to change. Taking that into account, the guideline sets out rehabilitation as a primary purpose of sentencing young people. Now that these three general guidelines are in place, we are working on preparing guidelines for specific offences. Scotland's first specific offence guideline is on the statutory offences of causing death by driving. Our offence guidelines are designed to provide guidance to judges while making sure that they have flexibility and discretion to take into account the unique circumstances of each particular case. Even though the specific factors of a particular case will be unique, the guideline will help to ensure that these factors are always considered at the same stage of the sentencing process. This will support consistency in sentencing. All guidelines must be approved by the High Court, and by law, judges must have regard to them. However, they're not required to follow them. There may be times when not following a guideline is appropriate given the particular facts of a specific case. If a judge decides not to follow a guideline, though, they must give their reasons. The second lecture in this series covers the guidelines in more detail, so let's move on just now to talk about some other types of work the Council does: guideline judgments, policy, research, and public education. In addition to producing sentencing guidelines, the Council also has a responsibility to publish guideline judgments issued by the Scottish courts. Appeal court judges have the power to make decisions in appeal cases that give guidance to other judges about the appropriate sentence to use in similar types of cases. These guideline judgments are still used alongside the Council's sentencing guidelines. You can see the Council website for more information on guideline judgments. As I mentioned at the start of the lecture, the Council also has a statutory duty to assist the development of policy. One of our first pieces of policy work was a paper on the perspective of judges in relation to community-based sentences. Through engagement with sentencers, we found that they commonly view community sentences as providing a greater chance of rehabilitation, but not all sentencers felt that they had a full awareness of what community-based options were available to them. We suggested a range of ideas to improve judicial confidence in using community-based disposals. We've drawn those findings to the attention of the Scottish Government as it continues to develop its community justice work. Other Council policy work has included contributing to the debate around the extension of the presumption against short prison sentences and to various consultations from the Scottish Government and elsewhere. The Council also has the power to research and publish information around sentencing and to give advice and guidance of a general nature on sentencing matters. We commission a range of independent publications, including on the research carried out in the development of each of our guidelines. For example, we published a paper on the brain development and maturity of young people, which significantly contributed towards the evidence base for our Sentencing Young People guideline. We also commission work on general sentencing matters, for example, around the obstacles which exist in comparing sentencing practice between jurisdictions. Public education is also an important area of the Council's work. As you will have gathered by now, improving public understanding is one of our key aims, and our guidelines are intended as much for the public as for the courts. We don't think that people will be sitting at home with time on their hands to read the guidelines, but we do think that they will serve as educational tools, for example, for students. We've also worked to create a number of user-friendly resources on our website. These include jargon and mythbusters, interactive case studies where you can play the role of judge, and animated videos, including around sentencing young people. In addition, we work with the media. Research suggests that some people's perception of sentencing is influenced by headlines and news stories, so we're working directly with certain journalists to discuss how court cases are covered. Independent research, which we commissioned around sexual offences, shows that members of the public perceived that sentences for these offences was lenient. However, when members of the public went through a scenario based on a real case, the sentence they selected was similar to that passed by the judge. When told this, participants were surprised. It may be that some media stories create the perception that sentencing is lenient. For example, when headlines say that an offender has been spared jail or avoided prison, when the truth is that community payback orders can be more demanding than short-term prison sentences. Our work with certain media has led to more detailed information about what sentences entail, including the full extent of what a challenging and demanding community payback order may include. I hope that you've found this brief introduction to the role and work of the Council helpful. We always welcome views on what topics we should consider for future guidelines, and we'd be happy to hear from you at sentencingcouncil@scottcourts.gov.uk. Please also contact us if you have any questions or other comments in relation to sentencing.